Eku Iluna, please rise. Aohea o ko e ko ka aha, inahe kuliana imua o kea aha ko o kolo kolo ki e ki hano hano o ka moku aina o Hawaii. I naoi mai, e malio mai, I lohe I ka leo. Hear ye, hear ye, hear ye. All persons having any business before this Honorable Supreme Court of the State of Hawaii, draw nigh. Give your attention and you shall be heard. E noho I lalo. Please be seated.
Velina, greetings. Makamoku kupuni o Oahu I ka moku o Kona, e ano ka koma aliolani hale. On the island of Oahu, in the district of Kona, we are gathered here at Ali'i Hale. Please call the case.
Case number SCWC-23-0000079, Marvin L. Thedford, petitioner appellant, versus Administrative Director of the Courts, State of Hawaii, respondent appellee. Arguing for petitioner Marvin L. Thedford, Kevin O'Grady. Arguing for respondent Administrative Director of the Courts, Deputy Attorney General Tiffany Chang. Argument on the merits.
Aloha ainala, good afternoon. Today's proceeding is being broadcast live on the Judiciary's YouTube channel. And I'd like to welcome our substitute justices in this case, Judge Catherine Remigio and Judge Taryn Tomasa. Thank you so much for joining us. Counsel, are you ready to proceed?
I am.
Thank you. The court has allowed 30 minutes for each side. Just to confirm, Mr. O'Grady, I understand you intend to argue for 25 minutes and reserve your remaining 5 minutes for rebuttal. And Ms. Chang, you will have 30 minutes with a 5-minute warning. Mr. O'Grady, please proceed.
Thank you. Madam Chief Justice, and may it please the court, alcohol-based standardized field sobriety tests were tested with specific blood alcohol concentration levels and only blood alcohol concentration levels in order to provide police officers with validated clues so that they could establish probable cause to arrest more drivers for the offense of driving with a blood alcohol concentration of 0.10 or higher. Through re-examination of the underlying studies, the National Highway Traffic Safety Administration, NHTSA, produced research to indicate that the SFSTs were also useful in providing probable cause for blood alcohol concentration of 0.08 or higher. Courts have, over the years, allowed performance on standardized field sobriety tests to be tied to alcohol impairment related to driving. NHTSA has made clear, however, that SFSTs were never designed, tested, or validated with regard to marijuana impairment, and of course, have never been made applicable to the analysis of whether or not a person has the ability to operate a vehicle in a careful and prudent manner, which is Hawaii's law pertaining to drugs including marijuana. Therefore, they are irrelevant to the analysis here. SFSTs are subjective and not able to be replicated later, and used outside their originally designed, tested, and intended use present a high risk of erroneously depriving drivers of their constitutionally protected liberty and property interest in their driver's license. The Coffey case prohibits a trial court from taking judicial notice of another trial court case with disputed adjudicative facts. The Coffey case does not stand for the proposition that alcohol-based SFSTs alone can establish probable cause or a preponderance of the evidence that a driver could not drive in a careful and prudent manner while smelling like marijuana. This court should overrule the ICA, rule in favor of Mr. Thedford, and clarify the Coffey case. I welcome the court's questions.
Well, Mr. O'Grady, let me ask you, you say Coffey doesn't stand for the proposition that SFSTs may be used alone as sufficient evidence to prove intoxication. But I'm not sure that that's what the ICA said or what the hearings officer said in this case. There was a lot of other evidence surrounding the SFSTs. Isn't that true?
In the Coffey case or in Mr. Thedford's case?
No, in this case.
No, I disagree. With regard to Mr. Thedford, there was no, and this is key, there was no bad driving. There was no indication whatsoever that he was driving in a way that was less than careful or prudent. The vast majority of the hearing officer's findings, and the ICA confirmed this, relied on many of the errors or the observations that the officer made with regard to Mr. Thedford's performance on the standardized field sobriety tests.
The initial decision to administer the SFSTs, though, was based on the fact that there was a strong odor of what the officer believed to be marijuana emanating from the vehicle, correct?
The officer did make that choice. I think that's an erroneous choice, but it is a choice that the officers will frequently make because they only have one tool. As NHTSA pointed out, they only have the standardized field sobriety tests that were never tested for marijuana, but the officers only know standardized field sobriety tests. They have no other tool to establish impairment by marijuana, so when they smell marijuana, which has for decades prior been illegal in any form, they want to see if they could find some sort of impairment, and they only have one tool. And when you only have a hammer, everything looks like a nail. He gave him the standardized field sobriety test because that's the only tool he had.
But the studies that you admitted into evidence before the hearings officers, which focused on alcohol, those studies focused on alcohol. But there are other studies that were submitted along the way, I guess, for purposes of judicial notice before the ICA, and you even submitted a variety of reports and studies to our court. A lot of those studies reference the fact that it's toxicology that has not been scientifically proven with regards to THC levels. For instance, you cannot show scientifically that a certain level of THC toxicology from a toxicological standpoint means that somebody is impaired. But there is a reference in those same studies about use of SFSTs as an indicator of impairment for marijuana. Isn't that a fair reading of those studies?
I think NHTSA wants to have the officers use the SFSTs as much as they can to gather as much information as they can.
Yes.
But I think that NHTSA also recognizes and clearly has stated that they don't have validated clues that establish any mistakes in the SFSTs as being indicative of impairment by marijuana. And that is because the SFSTs, again, were originally tied not even to impairment by reason of alcohol consumption, but to a specific blood alcohol concentration. Over the years, NHTSA has allowed, and courts have used, standardized field sobriety tests to bring in the concept of impairment.
What is your position then on what an officer can use to assess marijuana impairment?
So that boils down to a lay person's opinion of what would a person who, by reason of marijuana consumption, is unable to drive in a careful and prudent manner. And I think colloquially they might use the word impairment, and you would be looking for things normally associated with gross impairment. So if we asked Mr. Thedford, would you consent to speak to me for a few minutes? I'd like to find out some more about you. And Mr. Thedford exited the vehicle and had to hold on to the vehicle, stumbled out of the vehicle, staggered as he made his way to the sidewalk, and then could not stay still but kept falling over and changing his position as he spoke to the officer. Those would be an indication that, if described properly in the police reports, could establish probable cause and perhaps even a preponderance of the evidence that, since there doesn't seem to be anything else on board other than marijuana, that perhaps he is unable to drive in a careful and prudent manner, and it's because of marijuana. But the argument here is we are missing those things with Mr. Thedford. He does not exhibit any of those things. The closest thing that he exhibited was similar to me leaning forward into the microphone. While having an officer a foot away from him, he had a lean of a couple of inches while talking to the officer. With regard to nearly everything else that the officer relied on and the hearing officer at the ADLO relied on, it almost all, and the vast majority of it, relies on those errors or mistakes that the officer attributed to things that he normally looks for in standardized field sobriety tests, whether or not he missed a step or made the turn incorrectly, etc.
The SFSTs, though, go to balance and coordination, don't they? Isn't that similar to what you just recounted, except perhaps you're underlining gross imbalance and
But I think
lack of coordination?
I think that's important too, because the underlying studies indicate that when you attempt to do things, they deliberately create additional problems, even in the SFSTs themselves. Nobody walks heel to toe because it is naturally unbalanced. Nobody walks heel to toe with their hands at their sides, as opposed to out in some fashion to enable balance. They are already putting people at a disadvantage, even in the standardized field sobriety tests. And then after they did that, they said, but people who have consumed a specific amount of alcohol, 0.10 or higher in the blood alcohol concentration, tend to make these mistakes, and they tied them to that. They have never done that with regard to marijuana impairment. And the studies that you've mentioned, Justice Ganoza, talk about how marijuana operates differently. It does not necessarily, I think, always manifest itself in the unbalanced nature. It may be slowed reactions or what have you. I don't know
Well,
what
let
a
me
late.
ask you that on the balance. Has there been any, does marijuana impair balance? I mean, we often think of somebody who's drunk staggering around. Hard to envision somebody who's marijuana, at least in popular culture, staggering around. What is the correlation between marijuana impairment to carefully and prudently drive a car and balance?
I don't believe any's been established. Unfortunately, I myself don't know what the common theory would be, and I also am unfamiliar with any case law that says a layperson would normally associate this particular behavior with marijuana
Well,
impairment.
aside from, what is the basis then, if you know, of the assertion that marijuana impairs balance?
I don't know that there is such an assertion. I merely put out for Justice Ganoza that it is possible that the officer, and perhaps the ADLR officer too, would look at something such as gross staggering and say, well, he seems to be, his balance is so impaired. I think you can infer that perhaps he cannot drive in a careful and prudent way. But I don't know that there's been any studies or any cases that indicate that a lack of balance is associated, from a layperson's perspective, with impairment by marijuana.
What about balance in general? There might be a 65-year-old person who might not have the ability to stand on one leg. Again, what is the correlation between balance and careful and prudent driving?
There isn't any. I don't believe there is any. And that's why I think it's imperative that the police officer and the hearing officer be able to establish something that connects the driving with the consumption of marijuana.
Is balance more of an indication that somebody might be intoxicated under alcohol versus their ability to drive a car safely?
I'm sorry, can you ask that again?
Is these balancing tests and these coordination tests are, and you mentioned that they were designed for alcohol and dose dependent and all that, this amount of clues equates to probably above a 0.08 and things of that nature. But it strikes me that when those tests are undertaken and we're looking at the balancing context, I'm wondering what you can share as far as what that might be to correlate to the driving versus just being drunk or intoxicated on a drug.
So it is my position that the standardized field sobriety tests, and specifically the balance portions to which you're referring to, Justice Edens, don't bear any relation at all to driving. Either under the alcohol assessment, which is the ability to guard against casualty, or the drug portion of the statute, which is to be able to drive in a careful and prudent manner. However, I recognize that there is a significant amount of case law that attributes the inability to do the balancing portions of the standardized field sobriety test as being related to, and thus a fact finder, such as a hearing officer or a court, can infer that therefore they would be unable to drive under the alcohol portion anyway, the inability to guard against casualty, which is alcohol related.
Is sorry, go ahead.
No,
Is my understanding correct that NHTSA considers STs basically invalid for people over 65?
The National Highway Traffic Safety Administration is very careful to say that people over 65 should not be given the tests. Similarly, people with inner ear, back, or leg problems, and people who are overweight should not be given the walk and turn and the one leg stand tests, the balancing tests. They are careful not to instruct the officers by using such mandatory words as, you shall never give these tests to people who exhibit these things. Again, the whole purpose behind the standardized field sobriety tests was established to give the officers a tool to arrest more people. When these tests first came out in the 1970s, it was the belief of the National Highway Traffic Safety Administration that officers encountered people who had alcohol in their system on the road, and by doing whatever test they were making up at the time, or just a visual assessment, they would let people go, and they thought that more people were actually over the limit. And back then it was more related to having a blood alcohol concentration of 0.10. It actually started higher than that, earlier than that, it was 0.15. It's gone down steadily through the decades. What they wanted to do was give the officers the ability to arrest more drivers, and so they developed these tests, tied them to a blood alcohol concentration of 0.10, and they thought that those arrests would give them the probable cause. Case law has taken it such that you can then use these tests to also prove impairment in the criminal court, and you could also use them even to prove proof beyond a reasonable doubt. But that's not the way they were originally designed. They were just designed to give the officers an additional tool.
For probable cause.
For probable cause, yes, to arrest more drivers for DUI. The first 20 pages, I'm sorry, it's not in the record.
Because if a person that's overweight or has an inner ear problem or is over 65 and can't keep their balance and therefore would have indicia of intoxication.
Yes, and
but there might not be a real probable cause for. So how does this all relate to actual intoxication then?
So it depends upon the definition.
Or inability to drive in a careful and prudent manner.
Right. I don't think it does. Standardized field sobriety tests, even the she's called the godfather or the godmother of the SFSTs, Miss Marceline Burns, said they are supposed to be tied to a blood alcohol concentration. They were never meant to tell us anything about the ability to drive. So over the years, the courts have adopted a connection between a specific blood alcohol concentration and impairment in the general sense, that is an inability to drive under alcohol. And again, none of this, whatever connections there are, which of course the DUI bar has greatly fought for past several decades, none of this has ever been tested or adopted with regard to the consumption and ingestion of marijuana. And more importantly, an inability to drive after one has...
What if there was a drug that had symptoms consistent with marijuana? And I know you're saying the SFTs are so alcohol-based and they're alcohol-related, but what if there was a drug that had symptoms very similar to alcohol? Would your position be different?
No, because the DUI drug statute here in Hawaii does not break out marijuana into its own category. It says drugs. So there could be any number of drugs that either I'm vaguely familiar with or unfamiliar with at all that have similar symptoms, they're processed in a similar fashion, and they manifest themselves in the same sort of way when a person does either SFSTs or they're walking around the car or they're driving. It may be that some other drug produces the same sort of symptoms. It may be a legal drug, it may be an illegal drug. The statute does not break out marijuana. So if you are taking a prescription drug, an authorized amount of a prescription drug that you are authorized to take that drug, if it affects you in a particular way such that you cannot drive in a careful and prudent manner, you would be in violation of the DUI drug statute. How the officer establishes that has to be, I think, taken in a holistic fashion. And I direct the court to Jones footnote 32, which cautions against standardized field sobriety tests, which are coming from an officer. The officer has been trained specifically to look through the lens of the SFSTs. And so everything he sees is not going to be the same as a layperson would see when a person is walking a straight line or standing on one leg. So I think that if you have a drug that mimics marijuana, it has to be that you cannot drive. And I think one of the key things that is important for them proving that is I was
talking about a drug that mimics alcohol, because you're saying that because FSTs were really alcohol related, they cannot correlate to a marijuana situation because, you're two different things. But say there was some, a similar drug, exactly like marijuana, maybe it was synthetic marijuana, that really impacted the central nervous system. Why wouldn't the SFTs for that particular drug, not talking about marijuana, be all right?
For the same reason, it hasn't been tested. Certain synthetic drugs like spice have come up in many recent years, especially in the military. They produce a wide-ranging set of facts and manifestations after you consume the item. If there was a version of that that mimicked marijuana, studies can be had. NHTSA has in their congressional report that was submitted to the ICA, they have asked for additional monies and studies so that they can figure out how drugs affect the body, how they affect your ability to drive, and what tools they can give officers related to driving. They specifically addressed marijuana because of the prevalence of marijuana in recent years, but it could be done with any other drug. And that's what they need to do in order to establish the requisite findings of preponderance of the evidence and probable cause.
Well, I'm going to just point out that, the things that you have submitted, including the NHTSA drugs and human performance fact sheets, every 10 years, right, there's a group of experts that get together. They address trying to assess how to determine impairment, driving impairment. And those fact sheets specifically address cannabis and speak to, I want to quote from it, basically, they talk about indicators for impairment. It includes bloodshot eyes. That was the situation in this case. It's the smell of marijuana on the person and in the vehicle. That was in this case. And poor performance on field sobriety tests. So I'm a little bit confused by your argument because I understand what you're saying in terms of toxicology with regards to alcohol. There's evidence as to a certain toxicology level for alcohol, and there not being one for marijuana. But SFSTs have been recognized as indicators of impairment vis-a-vis marijuana in these same studies. So I don't understand, I'm not following your argument that it needs to be studied and SFSTs need to be completely ignored. They're completely irrelevant in these kind of cases.
I'd like to address that, Justice Ganoza. So first, the drug performance sheet to which you referenced was not before the hearing officer. That was not in evidence. She took it out there, and I don't believe it's able to be judicially noticed by the ADLRO, and that is something that she based her ruling on without it being before me. I did not submit that, and obviously the police officer did not submit that. That document purports to cover every drug known. As you know, I cited, I think it was Benadryl when I was talking about it. The expert panel to which you refer in that summary with regard to marijuana does not break out how they arrived at that conclusion. And it is contrary to the congressional report that NHTSA submitted, where they say SFSTs were not tested and they cannot tell us whether or not a person has the ability to drive, and so, or safely. And so that expert panel is going off of, we don't know what studies. That is not referenced in there. There are a bunch of citations at the end with regard to each citation for each drug, but they don't tell us that they've ever done a study where they gave people marijuana, what level of marijuana, of what purity and what frequency, and in what time related to driving, because as was pointed out in the studies, if you smoke marijuana at 9 o'clock, it does not affect you at 9:30 the same way as if you had 2 drinks at 9 o'clock. Those being in your body at 9:30 would affect you.
So let me just stop you there. The difference, I think what I'm hearing you say with regards to alcohol is that there are studies specifically as to how alcohol levels affect impairment. There are many cases where involving alcohol impairment where there is no BAC that is put into evidence, and the case goes forward simply on other evidence, right? How is that different than this situation?
So there's 2 things. First, in a case where there's no breath or blood alcohol concentration in an alcohol case, the state is going to rely on one of 2 things. Putting aside another case, which is before this court later on this month with regard to declining the performance of standardized field sobriety tests. If the person does the standardized field sobriety tests, then the state is going to rely on all those years of case law that says performance of standardized field sobriety tells us an impairment aspect, and so they will rely on that. In the absence of standardized field sobriety tests, the person was unable to do them, refused to do them, whatever, if there's no inference there, then the government is going to rely on lay opinions or lay observations with regard to what is commonly interpreted as being unable to drive safely by reason of alcohol. And those things include gross inability to balance and walk, and a regular person could say, I know, I've seen people that are impaired that I wouldn't want driving, and because they consumed alcohol, and that person there, that defendant, he looks like that. I would not let him drive. I don't know what the lay opinion is for that after the consumption of marijuana. I don't know if there are any cases out there that establish that. Certainly, unless there was very bad driving, which is missing in Mr. Thedford's case. There's no driving whatsoever. And I don't think there's any gross difficulty in him leaving the car or in walking over before he performs the standardized field sobriety tests. Almost the entirety of what the hearing officer and the ADLRO hearing officer and the ICA relied on was how he performed the standardized field sobriety tests.
Well, I mean, the totality of the circumstances was he was
Of
very
course.
enthusiastic about doing the SFST.
He did, yes. He said yes. Yeah, he
He
was
said, "Oh, yeah."
somewhat enthusiastic.
Right?
Oh, yeah.
Something like that. And then he got out of the car and
Right.
proceeded to do the test.
Right.
And there are the other indicators that we've talked about. But my point is, I think a lot of the case law it speaks to the totality of the circumstances.
Of course.
I don't know that any case necessarily says SFSTs are enough in and of themselves.
For performance of alcohol?
Right.
Well, it is, no. I think in every case for alcohol-related DUIs, I don't think there's ever a case that says SFSTs alone, but it may be that SFSTs were the only thing that was there. They pulled him over at a roadblock. There's no bad driving whatsoever. And then they conducted SFSTs. He refused a preliminary alcohol. He refused a chemical test after, and all they have is the SFSTs. There are people that are found guilty for that all the time. And so it could be that that is what forms the basis of the conviction. And that would be enough for ADLRO as well if they were stopped at a valid roadblock. And I see that my light is on. So-
Speaking of what is sufficient for ADLRO, please, if you could help me understand. My understanding is 291E61A2 says that someone operates a vehicle under the influence of an intoxicant while under the influence of any drug that impairs the person's ability to operate the vehicle in a careful and prudent manner. That's what he was, because there was no evidence of alcohol,
That's
correct? But when you look at the findings, it just said, conclusion, it says that by a preponderance of the evidence, respondent operated the vehicle while under the influence of an intoxicant. And it doesn't say anything about careful and prudent manner. Is this sufficient?
No. And that's
Did
because-
you raise that?
I did not. What I raised was that what the hearing officer, I believe, communicated in her finding was that she found that he was impaired by a drug, and there are references in her findings to marijuana, so that's what she meant, that he was impaired by a drug. And her use of the terminology impaired, the way she's using it, is loose for not in a careful and prudent manner. And briefly, in answer to your question, Madam Chief Justice, there has to be a preponderance of the evidence, and a reasonable person would establish it also under probable cause. With the number of potential errors that are made by people that could not perform well on standardized field sobriety tests for any of the reasons raised here today, and the potential errors, since they've never been associated with marijuana, there is a grave risk, and I don't see how we can get to it being more likely than not that a preponderance of the evidence exists, or that a reasonable person would believe under the probable cause standard that he was impaired by marijuana such that he was unable to drive in a careful and prudent manner.
May I clarify one thing? With regards to the ultimate revocation of license, he also refused the testing.
That's true.
Isn't that so they revoked for 2 years?
That's true.
Right? Under subsection 41 of that chapter.
That's true. And it was my argument that Because there was not probable cause for a proper arrest, they could not invoke the statutory scheme of implied consent. If an officer just rolls up on somebody and smells marijuana, they can't say, "You're under arrest, you must provide me with a chemical test."
So let's be clear, the arguments as to SFST goes to the probable cause only for the arrest, which led to his refusal of the testing, which led to the 2-year revocation.
So it goes to two parts.
You think, so your argument is it also needs to be proven by a preponderance of the evidence that he was in fact impaired.
Yes, and it's lacking.
Thank you. Ms. Chang?
Thank you. Good afternoon, and may it please the court. The field sobriety test is about impairment, full stop.
Could you lower
Oh,
the
I'm so
microphone?
sorry. Yes.
It's okay.
Oh. So the field sobriety test is about impairment in and of itself. It is not dependent on the substance of which somebody is impaired. It is a psychomotor skill test, and it is meant as a triage to see if this specific driver can control their mind and body to the extent that they can drive in a careful and prudent manner.
Why is it not administered then to people with inner ear problems or are overweight or are 65 or older? Or it's not encouraged or not supposed to be?
Sure. So the history of the field sobriety test, when it was developed, it was intended to create a standardized battery for police officers to use in the detection of impaired driving. Because prior to that, I think it was a little wild what we were doing. But because it is standardized, people are individualized. Everybody is going to have different physiological abilities. Maybe you have specialized training and you have exceptional balance, et cetera, et cetera. And so when you have a standardized battery, it's really more of an average experience of like what we would expect a human to do. And so when you start adding in concerns about the fact that as we age, you know, some of our joints don't work the same anymore. I know I experienced that. That is also why, though, the field sobriety test starts with the medical rule-out questions, because it is imperative that the law enforcement officer know, is there something else I need to be taking into account when I am evaluating whether or not I think this person is safe to be on the road? And so even though it is perhaps, I wouldn't say that it's like not advised to be administered to them, but it is a factor that would go into the determination that the police officer make in the end. Because again, like the field sobriety test, like sure, if you take everything kind of separately, it seems kind of silly and unnatural, but driving is actually really unnatural. Because, right, like we are sitting in a chair using like our feet in kind of a nuanced manner for like 2 pedals, maybe 3, while also directing this heavy machinery down the road, trying to maintain our lane spacing, also maybe the shifter, if it's a standard car, but you also have the windshields, the turn signals, while also looking around to make sure that you're not going to crash into anything and nothing is going to crash into you. And all of this time, like, we're also doing this while following a set of instructions and laws that we might have learned as teenagers. Like that actually asks a lot of people's like mental and physical abilities. And sure, like as time goes on, we get very comfortable with driving and we have to focus a little bit less on it, at least intentionally, but our bodies and our minds are still going through all of those processes. So again, like the field sobriety test is meant to be a triage, just to know, like, can we connect all of that? And sorry, the fact that when studies talk about the field sobriety test as, quote, validated to alcohol, what it's really talking about is that correlation between performance and a specific blood alcohol level. And the reason we have that is because alcohol metabolizes in the body in a very predictable manner. It's actually very simple in terms of how it affects the human body in comparison to other substances. And so there is a threshold that was established at which point over that you have an elevated crash risk. And so when we want to extrapolate the performance of the field sobriety test to the blood alcohol level, what the studies were showing, and this is true in the 3 studies that were submitted by the petitioner to the ADLRO, is that is that officer going to be able to tell if you're over or under that threshold, which is really kind of about the per se laws, because it is per se.
Are our courts convicting people of OVUII for alcohol based on like a safety check stop and just based on FSST?
I think it would be really fact dependent on that case. It's a little hard to say, right? Because this isn't, we're not here today for a criminal case. This is an
But
administrative case.
yeah,
But
I understand, but like coffee that the hearing officer cited too, I mean, that the person was weaving, right, and speeding, and that's why they were pulled over. So it seems like the facts there are just so different than this case.
it's always tricky with OVII charges because it does kind of, I think the gut reaction is to say like, well, there must have been something obvious. But the fact is that intoxication isn't actually always that obvious, even to the person who is intoxicated. They might not actually understand or know how impaired they actually are, and therefore,
But where is the evidence? Okay, so, all right, the issue here is probable cause. We're not really addressing the findings here. The issue is whether or not there was probable cause for the arrest,
yes.
right? Okay.
So, you were saying, I guess, sort of the diagnostic interpretation with the, the design of the FSTs and, the clues, and they show, this person was compromised, so they're in all likelihood above 0.08, and that's sort of that diagnostic sort of interpretation. But, if you strip that away and you're just left with, say, the officer saying, the person swayed a bit and had, a hard time balancing. I mean, that's really the lay observation we're talking about. Why do we even need the FSTs then in drug impaired cases?
It's the fact that because it is standardized and these officers are trained to administer them in a specific way, that we can then trust that what the observations that they're telling us is really the kind of the conclusions that they were supposed to get to when we're seeing that. Because it does kind of come down to the difference, I think, between like alcohol and all other drugs and substances, because alcohol is not a controlled substance the way everything else is. So we are very familiar with what a person looks like when they're under the influence of alcohol, as opposed to a controlled substance, because we're just frankly not exposed to them as much. And so when a layperson could like say like, hey, I think this person might be intoxicated, but do they really know? No, it's the officer who has had this training and gone through this process that understands like how, the performance on the SFST relates to your ability to drive. Because again, like it's true, like nobody's standing on the side of the road with their leg up, but at the same time, like the SFSTs were also designed to be quick so that we're not exposing people on the side of the road. And also to be easily.
But I guess what I'm saying is, why even do it? Why not just have some sort of a generic balance test? Hey, why don't you raise your foot a couple times? Why not? Hey, I got a pogo stick in my car trunk. Why don't we see how you can hop? I mean, I just wondering why the FSTs? Do you need the FSTs if we're just supposedly doing lay observations about somebody's coordination level?
Because it would be really difficult to apply that to everyone. I mean, because then a driver, whether they would get their license revoked or whether they'd be criminally charged, would really then kind of depend on luck of the draw. Like, is this officer going to make me jump on a pogo stick, or like, is there going to just, I don't know, walk in a line? And again, it's meant to also be simple enough to explain to the driver and then to have them do it. So I actually don't know how to jump on a pogo stick. So if somebody were to just give me instructions to do that, I think I would have a unusually difficult time, as opposed to somebody who would. And then we would get into some concerns maybe about like due process.
Well, if it's lay observation, then maybe not pogo stick. Why not? Okay, lift up your leg and keep it there a few times without even going through medical rule outs and stuff like that. I mean, I just what is the correlation between the test and what we're trying to figure out here? And Mr. O'Grady says, hey, look, we need something more than just, if the guy, for example, a natural observation, he stumbles out of the car or he's talking with the police officer and he, falls down or she falls down. I mean, that might be some manifestations that they could use to justify probable cause. But this elaborate alcohol-designed test, I'm just wondering if that context divorces it from the drug context.
I don't think so, because again, like it's really not about the substance that is impairing a person. It's about their ability to physically do the field sobriety test. Because the field sobriety test, again, like you're given instructions to follow, and then you need to tell your body how to do it, and then to actually do it. And the physical mechanics of exiting a vehicle to walking down on the side of the road is going to be different than the field sobriety test. But the field sobriety test levels the playing field for everyone. It makes it so that everybody is judged by the same standard and that the officers can make an assessment that it's not this individual person where that is showing a lack of balance or coordination. It is that this average person is being impaired by something that is making it so that they are showing a lack of balance. And so in that sense, like that is why it correlates simply to impairment.
But isn't the correlation based on the alcohol consumption? So you're talking about how the officers are trained. This is a standardized test. It's so that everybody's results can be fairly judged. But here, it's correlated to alcohol, not to any generic drug.
It's not actually specifically correlated to alcohol. These studies, as validation studies, as they are titled, they are meant to apply the field sobriety test, which is, again, a test of your psychomotor skills, onto the blood alcohol content scheme. Because those are really more relevant to statutes that have a per se limit, wherein you are per se under the influence if you are over a specific blood alcohol level. And again, that level was established because alcohol metabolizes so predictably that they could tie that to a specific point where you have an elevated crash risk. And that's how we established those laws. And so yes, it would be really necessary to know, like, does the performance of the field sobriety test make it so that this law enforcement officer can make a determination that this person is over that level? Yes, because if they're regularly arresting people who are below it, that would be a huge problem. But the field sobriety in and of itself isn't about that. And because we don't have a per se drug law in Hawaii, our standard really then is just about, can this person physically and mentally drive this car?
But is that based on the cues that the officer marks off on the SFST? And those cues are correlated to alcohol.
This field sobriety test, those 3 specific tests were chosen because out of basically in the 1970s, when they were conducting those initial studies, they were trying to determine like which of the various field sobriety tests that were being administered around the country would make the best battery, would make the most, that would make the most sense. And yes, it is true that with alcohol specifically, you can expect to see a horizontal gaze nystagmus as opposed to other intoxicants. But again, that really kind of makes sense because you are not going to see as many people on the road who are under the influence of an intoxicant that is not alcohol. And the field sobriety test, as it's designed, isn't meant to only rule in indicators of alcohol, as opposed to it is also meant to rule out other things. And it is the basis of the drug recognition experts protocol that they do. Marijuana is part of that matrix. And so when they are going through those steps, it is also to determine, is this person maybe not intoxicated by alcohol, and therefore we should go into that protocol.
Ms. Chang, standard field sobriety testing is not unique to Hawaii. It's done nationwide.
Yes.
It's addressed by NHTSA in a variety of reports, et cetera. So with regards to its use related to marijuana intoxication, there's a number of cases that have recognized that it's relevant. That's the question here. The precise question here is, should they have been those, the evidence as to those tests, should they have been inadmissible, completely inadmissible here? But in a number of cases nationwide, they have been deemed relevant and admissible. Do you know of any state that has ruled that they are completely inadmissible in the context of marijuana?
No, all 50 states participate in the drug recognition program, which is currently called the Drug Evaluation and Classification Program. All 50 states do follow that. And again, like the SFST is built into that protocol. So I would say that no, there wouldn't be any case law that would say that.
Yeah, I'm aware of cases that positively say they are admissible, they're relevant, not as necessarily expert evidence, but that's what I'm wanting to understand from you, is whether you are aware of any case where they have been deemed inadmissible in marijuana impairment cases.
I am not aware of any, and I would think that if it was deemed inadmissible, I would need to read the opinion to know if it was for a different reason. And again, this is an administrative revocation, so when the hearings officer was making their determination under 291E38, what they're looking at is, was there reasonable suspicion to stop this car? Was there probable cause to believe that the driver was operating a vehicle under the influence of intoxicant? And then by preponderance of the evidence, does it show that they were operating a vehicle under the, and I understand in the findings of fact, like that is the language that the hearings officer used, but it does seem more that the hearings officer was tracking the language of E38 as opposed to stating like, I find that by preponderance of evidence this person was intoxicated by marijuana specifically, because the statute is operating a vehicle under the influence of an intoxicant, not alcohol, marijuana, etc.
I understand that everyone's talking about the layperson's opinion, and you are probably talking about the officer, correct?
Yes.
But in some cases, there are body-worn cameras, right? In which you can review the interaction between the officer and the driver when they're explaining. Is the person nodding? Is he understanding? Is he looking away at the ceiling? Or how that person actually goes through the test itself. And could the layperson's opinion be the, that's not a judge in this case, it's a hearings officer. Would that also be applicable? I know it's not this case because there was no body-worn camera, but in many ways, the trier of fact is limited to what's offered in evidence. If this was a case with a body-worn camera, you could be able to see all the other nuances that occur. Would that be something that the trier or the hearings officer could point to and say, I believe that this reaches a level where this person is impaired?
I would think that the hearings officer could make that finding on their own, or the trier of fact, whoever that might be. It would be really no different than just judging the credibility of any other testimony. The trier of fact is going to compare it to whatever other evidence is presented in order to make that determination.
Because there isn't really a question here. I mean, maybe there is and I missed it, but there's no question about the under the influence part. It's the whether it was impairment, whether it was to such a level that it would have impaired his ability to drive in a careful and prudent manner.
Yes.
Okay, thank you.
And 291E61, like A2, like again, even though it's about drugs, the definition of drugs is any controlled substance in Schedules 1 through 4. And marijuana is technically a Schedule 1 drug. But this does also include prescription medications and other medically used substances. It includes things like ketamine, testosterone, zolpidem, which is Ambien. And these are all things that we know have like, an impact on the human body, on a person's mind and body. But again, like the driver themselves may not necessarily understand that until you're put into a situation where maybe you need to demonstrate it. Because again, like the longer you drive, the more comfortable you become behind the wheel. But you are still asking a lot of your body and your mind in performing that task. It's very uncomfortable at first, but as time goes on, we do become more comfortable until we're forced into a situation where maybe our route to work has changed because of construction, or suddenly we're driving a much bigger vehicle than we're used to. And so again, like because driving itself is unnatural and it requires so much of a person, that is why it is necessary to be able to demonstrate these psychomotor skills that on the SFST. And again, like, yes, individually, they do seem kind of silly, but it's part of that totality. It's part of taking it all together to determine whether or not this person can operate a vehicle in a safe and prudent manner. And all of this is because there is a strong public interest in preventing an accident or some harm to people because somebody is driving under the intoxicant. It should not be to the point that they are going to cause this, that law enforcement wants to step in. It is about both deterrence as well as safety. And so while it does seem a little strange sometimes to take the SFSTs out of the context of alcohol, because that is primarily what anybody is going to see under the OVI statutes, but that still is applicable to the drug context. And this has been
Can you
used.
repeat that? What did you say? Say that again? It's unusual because why?
I think that a layperson would probably expect it only to be in an alcohol-related DUI or OVII case.
Why is that relevant for whether it should be admissible in an ADLRO?
It's
setting?
not, because again, SFST is about impairment. It is simply about impairment. It doesn't really matter what the substance is. And I would note too that the studies that were included at the ADLRO level, they do actually cite to a 1994 study that says specifically that a retrospective analysis of the records of the Phoenix DRE unit found that a suspect's performance of the test did prove valid clues of drug impairment. So again, the SFST is applicable to that context, and it is not validated just for alcohol. And because Hawaii does not have a per se drug law, that is even more so the case here. I would simply return the court to the fact that if we take the extension of what the petitioner is arguing here, and that we say that the SFST is only going to be for alcohol, then that does mean that police officers don't have any tools to deter or to.
Well, Mr. O'Grady says that they have to be grossly challenged, motor skill wise and otherwise, and essentially quite obviously perhaps falling over. And that might be enough. I mean, I'm not sure where the line might be or how you define that.
That seems to.
Or how officers define that.
Sure, but having to require that seems beyond what is careful and prudent. Because again, like driving a vehicle isn't something that necessarily requires all of your gross motor skills. It also requires your fine motor skills. It's a very nuanced moment. You're not just like shoving your foot down on the pedal, in the way that we would expect to see if we were to be grossly intoxicated.
Well, the studies talk about divided attention too. The SFSTs are intended to assess whether an individual can be doing and concentrating and focusing on multiple things at a time, which is akin to operating a vehicle. I mean, so I guess the question for me is, ultimately, I mean, the argument comes down to, for Mr. O'Grady, hey, SFSTs were designed initially and created because of alcohol impairment and to show alcohol impairment. And reading a variety of these studies, it certainly, NHTSA has addressed marijuana impairment as well. I mean, what I'm hearing you say is these studies also reflect SFSTs should be utilized with regards to marijuana impairment as well. But I'm not sure how I mean, sometimes I hear you going back and forth like, maybe it's more like for alcohol, but really it should be used for marijuana. What's your position here?
The bottom line is that this field sobriety test is about impairment for all impairing substances. It is not specifically for alcohol. The usage of the SFST in the drug context and the marijuana context comes through the drug recognition expert program, which from the LAPD, which became the drug evaluation and a classification program.
That's a
was
nationwide program, right?
Yes, it is. And it was actually developed around the same time as those original studies about the SFST. The DRE program was launched by the LAPD in 1979. So it's not that, the field sobriety tests were developed solely because there was a concern about alcohol intoxication on the road and then later on applied to the drug context and the marijuana context. There was concern at that time too. And the field sobriety test was then established as foundational really to the DRE protocol. There is a large portion of it that that goes through a field sobriety test, including additional divided attention tests. And though I'm not sure how much this court will be considering the appendices to the petitioner's briefing, because it is not technically part of the record of appeal. However, but if the court were to consider that, those additional studies, especially what was appended to the petition for the application for cert as Exhibit 6, it does kind of show that that marijuana is it metabolizes differently from alcohol. That is true. It might be more individualized than we can expect from an alcohol DUI case. But that is likely going to be true for any DUI or any drugs.
But it seems that what you're basically saying is, well, we don't really know whether this is going to detect marijuana impairment, or I say it's beyond use, because you can drive while drinking, you can drive while, smoking, but it's the ability to, guard yourself against, for safety reasons, and carefully and prudent, at least in the drug context. But it seems like you're basically just saying, well, we don't know whether this is going to really impair, so might as well, we'll just let the trier of fact, flesh it out. But I mean, isn't that, when we're talking about scientific evidence, the reason why we have reliability standards, such, 104 hearings with Montalvo, and so I'm just wondering how we sort of get around, if we were to adopt your position from the classic, hey, let's look at reliability, and is this really meeting scientific standards?
Sure. The difference would be then that especially like that 2017 report to Congress that was appended, what is really clear is that there is a tendency to want to do a one-to-one comparison between an alcohol-based OVII and a drug-based one. But marijuana apparently is much more complicated in how it metabolizes in a person and how individualized it is. It's going to affect each person so differently based on how they're taken into the body or ingested, about how long after. If effects are being shown 3 hours after ingestion, that is very different from alcohol, which is why the field sobriety test is important. Because again, it is just about the impairment itself. And so we cannot create a field sobriety test for every single drug out there, nor can we individualize it to every individual person. And so having this standardized battery is what's going to give law enforcement the ability to assist with guarding against uncareful and unprudent drivers at the end of the day.
Okay, going to the specifics of this case, there was a refusal to do the testing at the station. Depending what part of the briefing I read, I thought the argument was there was no probable cause to arrest, and therefore, you don't get to the consent part of it, and therefore he shouldn't be sanctioned for refusing to take the test. Okay, so a lot of the argument, and the argument before the hearings officer was specifically inadmissible because of lack of probable cause to arrest. And then I don't know if it sort of has morphed into, do we need to address the actual proof by a preponderance of the evidence that he was impaired? What is your position on that?
Yes, there did need to be probable cause for the arrest in order to trigger the administrative revocation process.
Yes.
The preponderance of evidence comes in to look at the totality of the circumstances of the evidence presented to the hearings officer to decide if they met the statute of operating a vehicle under the influence of an intoxicant, thus triggering the revocation.
So in your view, 41, section 41 of chapter 291E, the refusal to take the test is not an automatic 2-year revocation. It is if you are determined to have been impaired under section 61, then you get the increased penalty of the 2 years. Is that what your position is?
Yes, I know. I see that I'm out of time, but just quickly.
Please proceed.
Thank
Yeah.
you. By the time we get to the hearings, there's actually been multiple reviews. So the way that the revocation would happen, after the individual has been advised or given the option, they read the forms for whether or not they want to take the test. If they refuse, then they are given additional information. Then they are given the
Yes.
permit. And then an administrator actually reviews it before issuing that revocation. And that is going to be based on the police reports and everything that is.
Isn't the only issue here probable cause? I thought Mr. O'Grady basically conceded that if there was probable cause, then the revocation was valid.
That's,
Yes, essentially yes. And then, but because once we get to the hearing officer's point, then,
So
yeah,
the issue is probable cause here, right?
yes.
And you would agree that under our case law, whether there are indicia of intoxication based on SFSTs is an expert opinion issue, not a lay opinion issue.
The drug recognition experts are usually admitted as an expert witness, yes. But in this case, all there is the police reports because there was no testimony taken. At
I
the
understand.
hearing, yeah.
I understand.
So it's a little hard
but
to say.
based on the police reports, but I'm assuming the police, I haven't read the police reports carefully, but the attack here is not on the expertise of the officer to evaluate indicia of intoxication based on NHTSA SSFT standards. But the issue is, if this is a matter of expert opinion, then doesn't there have to be something about the reliability of SFFTs and their correlation to marijuana intoxication? Because all the studies are based on alcohol intoxication, and it appears that certain criteria, failure to meet certain clues of intoxication, correlate fairly strongly with an alcohol level of a certain amount. And that's what provides the probable cause for the arrest.
Yes, because for alcohol, we do have, I guess, an impairment standard. We have a set, very predictable
So,
things
but,
to look for, yes.
but usually these cases there's some sort of moving violation. You know, usually it's somebody's swerving or speeding, or there's even an accident. And then the police officer arrives and there's an odor of alcohol, and then they say, could you do the field sobriety? And they, that type of thing. But here, in a situation like this, where there's no indication of failure, a lack of ability to drive in a careful and prudent manner before the stop, how does the SFST establish the probable cause that this person was under the influence of marijuana to the level that they were unable to drive in a careful and prudent manner?
It is, not all alcohol-based DUIs are going to have the bad driving. And even though we can attach really predictable, very usual types of specific driving patterns that we would see with somebody under with influence of alcohol, does not mean that any of that is irrelevant for the marijuana context. And even if we were to there still needs to be reasonable suspicion to stop the vehicle. In this case, it was actually because the petitioner had a safety check that had expired in 2015.
I don't think
Yeah.
we're attacking the reasonable suspicion here.
But it is part of that totality of circumstances, right? Like from the beginning that if we were to have bad
We're
driving.
not attacking the issue is not reasonable suspicion. The issue is not administrative revocation. The issue is probable cause.
Yes, but when we are doing our analysis about probable cause, we're going to look at everything from the beginning. That does usually in the alcohol.
Someone with a safety sticker must be intoxicated?
No, but
No.
it is reason to stop the car. And sure, that is just simply a factor that goes into that mosaic that we look at to determine if there was probable cause. And so we would then continue to look at all these different things that occurred during that interaction to determine that. And that is what the hearing officer did in this case. Thank you.
I understand your argument. Thank you. There being no more questions, Mr. O'Grady, your rebuttal.
Thank you. Madam Chief Justice and also Justice Ganoza, I want to make clear that this is not just probable cause, but it also is a preponderance of the evidence question. On page 5 of the underlying motion that I've initially submitted to the ADLRO, it reads, finally, without the SFST's probable cause does not exist to sustain a revocation, and there is not enough evidence to meet the preponderance of the evidence standard. So we have raised both. Also, I disagree with my colleague that SFST detection was about impaired driving. I think it has been our argument throughout that the studies indicate that they originally tied it to a blood alcohol concentration of 0.10. Back when they first created these tests, they weren't really looking at impairment, and there were no laws about whether or not one was impaired. In order to be found guilty of DUI, you had to have a blood alcohol concentration of 0.10. And that's why they were trying to arrest more people. Madam Chief Justice, you asked whether or not people are being convicted of being pulled over for something like a safety check and then SFSTs. Assuming there's also the odor of alcohol and the standardized field sobriety tests and watery bloodshot eyes, yes, all the time. So there is sometimes where the stop is just a safety check and an expired registration, the bane of existence of drivers because they tend to be mismatched in the month. And of course, there's also DUI roadblocks. With regard to the coffee case, Justice Ganoza, you pointed out that there are a significant number of differences, and I agree that there are a significant number of differences between Ms. Coffey's driving and Mr. Thedford's driving, and I think that goes into the mosaic of probable cause, and also for here at the ADLRO, a preponderance of the evidence. May I point out that it took Ms. Coffey nearly 5 full minutes to give Officer Dowkin her documents. That lagging time right there could be inferred by the finder of fact. Am I done with my 5 minutes?
Please proceed.
Yes. That can be inferred by the finder of fact that she was unable to drive in a careful and prudent manner because, as my colleague pointed out, driving requires you to do a multitude of things at the same time.
I think your red light went on because you went a little over because of our questioning in your initial. So I'm going to ask you, I'm just going to point out, coffee is different also because the sufficiency of the evidence was addressed in a very brief manner. Then there wasn't a discussion as to what that evidence was that the court was relying
That's
upon.
exactly right, and we raised that. That standard is not applicable here, I don't believe. And also, Justice Edens, you asked about whether or not there could be a made-up test. That is, oh, can't we just test the person, you know, whether or not they can rub their tummy and pat their head at the same time or jump over. I think there's a reference to a pogo stick or something. The Walcott case indicates that this court's extra protections that we provide under substantive due process, including in administrative hearings, gives us an additional protection of fairness. And the problem with making up tests is that this is completely subjective. At the point of an officer who is looking merely to establish probable cause and preponderance of the evidence, with regard to SFSTs, it is more magnified because everything he sees there, he has been taught, must be some form of impairment. But again, it is not for any substance at all. There could be a variety of reasons why there are errors there.
Okay,
What's the
let me ask
difference
you-
between stumbling during an FST, falling down, being unable to stay up or get up, and gross staggering, and not during an FST? What's the
I'm s-
difference?
What's the difference between what?
What's the difference between, well, I think I'm using your words that you said it would be indicative if they were stumbling, fell down and were unable to get up, or gross staggering. What's the difference between that and doing that during an SFST?
So, if a person in attempting to walk 9 steps heel to toe in a straight line with their hands by their side, instead of merely having a gap between steps, or stepping off the line, or raising their arms, if instead they stumbled and staggered off to the side, that would not be something that is part of the SFSTs. It would be something that the person did. And I would think, and I would argue, that that would be something that the officer could use, because that's not a particular thing that the officer is taught to look for. These minor mistakes that they're taught to look for have been validated only for
But
alcohol
I
consumption.
think that judges are smart enough to understand that, simply stepping off a little bit might not be enough. But if the person is falling down, that would be an indicator. And doing an SFST gives the officer an opportunity to interact, gives the officer an opportunity to see if the guy walking around while he's talking, what's going on. The things I talked about with the body-worn camera, which I think is a great idea if they're not using it now. I know they are because I've seen it. But all of those observations would go into a determination by the lay person, whether it's an officer or a hearings officer or a judge. So those are opportunities to see the same thing that you said they should be looking for.
So if during a standardized field sobriety test, a person is standing there waiting, perhaps during the horizontal gaze nystagmus, and just suddenly falls over and stumbles over to the side, that is not part of the horizontal gaze nystagmus. And whether it be a judge or a hearing officer at the ADLRO, they would certainly be able to, and I would concede that that is something that should go into the mosaic of probable cause and a preponderance of the evidence, because they just stumbled over instead of just standing there. That is not present in Mr. Thedford's case. My last point is that my colleague mentioned that it could have any sort of drug. The standardized field sobriety tests are meant to cover any sort of drug that could have impact. Under that theory, that could include sugar, caffeine, tobacco, and even a number of things that are in there. NHTSA never said that it was about impairment, and it never said it was meant to cover any substance that might be ingested by a person. It was only tested with regard to blood alcohol concentration. Thank you.
All right, thank you very much, counsel. Thank you. The court will take this matter under advisement.
E ku iluna. Please rise. Ua ho'oku'u ia mai ne kea aha ho'okolokolo ki ike anohano o ka moku aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.